roundtable. My name's Catherine Atkinson. I'm chair of the Society of Labour Lawyers, and I'm very pleased to be able to welcome you to our launch of the pamphlet Towards a National Legal Service, New Visions for Access to Justice. I wanted to start with a few thank yous, which I know are usually there at the end, but just so we don't forget when we get into the discussions that we'll have afterwards. I did want to thank Charlie Faulkner and Gibson Dunn for sponsoring this evening and for the drinks and the nibbles. And I wanted to particularly thank Rachel, our administrator, and Millie, who have done all of the administrative work and making sure that we were able to host this evening, and a lot of the work in actually getting it pulled together and published. And I want to thank our speakers, the first of whom will be Stephen Hockman-Casey, who coordinated really what started this pamphlet in the roundtable discussion that many in the room were present at, with our then Shadow Secretary of State for Justice, Steve Reed. Though things have moved on in the last week, and we will be making sure that we're coordinating with Shabana Mahmood, our new Shadow Secretary of State for Justice, to ensure that she and her team have had a chance to read and absorb it. But Stephen, who is the former chair of the Society of Labour Lawyers, as well as having been chairman of the Bar Council, has always been absolutely crucial and pivotal in the work that we had done on access to justice and on various of our subgroups. But I think access to justice has always been core to the work of the Society of Labour Lawyers, which will be celebrating our 75th anniversary this year. And it's maybe unsurprising that we share a birthday with post-war reforms from the Attlee government in the NHS and legal aid. And I think that we are at an exciting time where we are doing everything we can as a society to be looking at legal reforms for the future to ensure that the incredible erosion of what is certainly what feels like a crumbling justice system can be reinvigorated and reformed to actually be fit for purpose for the times to come. And after we hear from Stephen and from Nick Madge and from Joseph Kellen, opening it up to a roundtable discussion. So hopefully we will be able to hear from all of you, especially when it comes to be looking at next steps and what more we can do to ensure that what will hopefully be future Labour governments can hit the ground running and making the absolutely vital reforms that are needed. So with no further ado, can I invite Stephen to come up to speak?
Thank you very much, Catherine, and thank you for all your hard work as chair this year and for your support for this project. As you mentioned, the Society of Labour Lawyers, it so happens, was founded 75 years ago in the late 1940s. I think a chap called Gerald Gardner, who later became Harold Wilson's Lord Chancellor, was primarily responsible for its foundation. And it has been known for many years, I don't know if it says this on this display behind me, as the legal think tank of the Labour Party. But the issue which brings us here this evening requires more than just progressive thinking. I hope we'll get some of that, but it actually requires urgent political action. As Catherine said, society has always focused on the unmet need for legal services, but that need has probably never been more acute than it is now. As most of us know, the LASPO Act 2013 drastically reduced the scope and reach of publicly funded legal help, and hence imposed further limits on access to justice for ordinary people and their families. The result of this can be illustrated by some figures from a survey which I saw very recently in the Law Society Gazette relating to MPs' surgeries. And a survey was done of 200 or 300 surveys, which found that 3/4 of constituent appointments related to legal issues. And of those who raised those legal issues with their MPs, 79% had not been able to instruct a lawyer. I think that's quite illustrative. And the problems faced by such individuals can, of course, be among the most basic and fundamental, such as retaining a roof over your head, retaining your job, or even retaining the right to stay in this country. It is as if, I suggest, the National Health Service, Labour's most profound achievement, failed to provide access and care for some of the most impoverished and seriously ill members of our community. So it's against that background that the Society of Labour Lawyers decided to redirect attention to the issue of access to justice. And as we heard earlier this evening, Labour's National Policy Forum meeting in the Midlands in July passed the following resolutions. The Conservatives have decimated access to justice, leaving thousands without legal advice and support. Labour is committed to transforming our justice system and improving access to justice. But the question is, how should Labour progress this undeniably crucial policy objective? And that's why, back in March this year, a group of people with detailed knowledge of the issues sat down at Middle Temple, and we had a discussion to try to identify and discuss the options. Not all those who spoke were speaking as Labour members. Not all were agreed on everything that is contained in the pamphlet and on all the points discussed. But some extremely useful proposals emerged, and the papers which were contributed to that round table have been gathered together in the pamphlet that we're launching this evening. And if anybody hasn't got a copy, there are plenty more on the table in front of you. My role was merely to convene the round table, and I'm glad that some at least of the actual contributors are here and can speak if they wish in the course of the discussion which will follow. But before that discussion, we will hear from two individuals in particular. First from Nick Madge, who sits here in front of me, who not only kindly undertook some key editorial work on the pamphlet, but also with Roger Smith, who's also here, wrote the first paper on a proposed national legal service. And secondly, we'll hear from the chair of the junior Labour lawyers, Joseph Kelly, who missed the round table, but who has contributed the last of the papers in the pamphlet, which shows that addressing the problem of access to justice will result in no significant additional costs to the Treasury, but instead will result in direct economic benefits. We called the pamphlet Towards a National Legal Service, but as Nick will, I think, explain, the delivery of legal services will remain broadly in the hands, as it is at the moment, of a range of providers, both, of course, in the private sector and in law centres and the like. But what such a national legal service will do is to enable the provision of what is so lacking at present, as all those visits to MPs' surgeries amply demonstrate, namely strategic leadership, investment in innovation and technology, and an emphasis on early advice and dispute resolution. So it's in that spirit, as I say, that we gather together, a similar number of people around a similarly shaped table in Middle Temple. It's quite nostalgic, really, and very glad you're all here tonight to see us off. And I'm going to hand over now to Nick. With many thanks.
Thank you, Stephen. It's a pleasure and an honour to be here at the launch of this excellent pamphlet. We all agree that access to justice is essential for democracy and the rule of law. There's no point in having democratic rights if they cannot be enforced. There's no equality before the law unless there is equality of access towards the law. There's no social justice, no economic justice without access to courts and legal justice. Criminal legal aid, which grabs all the headlines, but access to civil justice to enforce civil rights is just as important. This was recognised by the Society of Labour Lawyers 50 years ago, over 50 years ago. 2023 is the 50th anniversary of the reprint, the second edition of the joint Fabian and Society of Labour Lawyers report, Justice for All. I bought a copy soon after the second edition was produced. Now I can see all of you thinking, God, how old is this guy? But let me tell you, when I was 8 years old, my mates at school said, Nick, you really must get out more. There are more things in life than reading Society of Labour Lawyers publications. You can have a lot more fun doing other things. They were, of course, wrong. At its best, the legal aid system was transformative. It was introduced, as we all know, by the post-war Labour Catholic government through the 1949 Legal Advice and Assistance Act. It helped shift the balance of power within society. It aimed to provide justice for all, or probably how we put it now, justice for the many, not just the few. It enabled women who'd been abused to gain injunctions against violent men. It enabled tenants to prevent eviction and harassment by rogue landlords. It enabled workers to gain compensation from their employers for injuries suffered at work. And it enabled consumers to gain redress for faulty goods and dodgy services. But we all know that the legal aid system is now in crisis. The provider base has shrunk alarmingly. There are advice deserts in many areas. The current legal aid system is broken beyond repair. I was a housing lawyer, and the way that I'm looking at the current legal aid system is that it's like what was a fine building being allowed to disintegrate, to fall into substantial disrepair. It's been badly neglected so that it's in risk of imminent collapse. No repairs have been carried out for years. Indeed, worse than that, vital wings of the building have been demolished. They've been removed and they've not replaced. So there's a real risk of collapse. And what we say is that it is better to start again. It's better to start again with a new building, with a new vision. Patchwork repairs, reverse of the last blow, the 2012 Legal Aid Sentencing Punishment of Offenders Act, is the restoration of those cuts is not by its own enough. A new vision is needed, and that's what's set out in this excellent publication. Why the first chapter, proposing a national legal service, which Roger Smith and I wrote, is at the start of the proposal. But in addition, there are lots of very constructive proposals from very experienced lawyers and other people about what can be done in the short term, what the problems are, and what should be done to put it right. Any new service must focus on the needs of the people who use it. We must recognise that they will include the most disadvantaged and vulnerable members of society. Its services should be made available, we say, under a common brand by existing providers. Private practice, law centres, advice agencies, especially citizens' advice, and national charitable bodies such as Public Law Project, Shelter, and CPAG. But what we also say is that if existing providers cannot make the necessary services available, then the National Legal Service should have power to employ its own salaried lawyers. We are not proposing a nationalised legal service of the kind which some people advocated in the 70s and 80s. What we're proposing is a mixed delivery model, and that will provide, we say, the flexibility which is needed. So, as Stephen said, towards a national legal service, new visions for access to justice reflects the extremely productive roundtable meeting with Steve Reed on March the 20th. Given the number of experienced and articulate lawyers who are present in the room, there was a remarkable degree of consensus. It's rare to hear so many lawyers agreeing on so much. There was near unanimity, and that's reflected in the papers when you have the chance of reading them, the individual chapters. The pamphlet goes into a lot more detail, both about proposals for a national legal service and interim measures which are vital to repair the damage caused over the last 13 years. Now is not the time to discuss in detail. There needs to be lots of discussion. We don't know precisely what the position will be when we have a new Labour government. We know the financial situation will be dire. We don't yet know how dire it will be. So finance is a crucial point. I'm not going to talk about that, except to flag up 3 points. One, money will be tight. We must think creatively and imaginatively about this. No potential method of funding should be off the table. Secondly, it's vital that opposing litigants, people who are either sued by clients represented through the National Legal Service, or people who sue unsuccessfully people represented through the National Legal Service, it's vital that those opposing people pay the full amount of the cost of representing their opponents. It's the principle that the polluter must pay, and part of sorting that out involves abolishing the fixed costs brought in by the Amendment number 2 rules of this year. Fixed costs, which mean that those legal aid providers who are representing people through the existing legal aid scheme are not paid enough to compensate for the work that they do. And finally, I must flag up the extremely important chapter written by Joseph Kellen, exploring aspects of funding in more detail. I'm not going to trespass on his territory, but that is an extremely important, perhaps the most important part of this pamphlet. We have to, I would say, we have to ensure that there is a good, strong proposal in the Labour Party manifesto. Roger and I say that it should be a proposal for a national legal service. A national legal service, we say, has to be a priority of the first term of a new Labour government. So let's get it into the manifesto, but let's also, once we've done that, continue the debate, look at the detail, look at the justification, look at the way forward. One final point. Towards a national legal service contains radical proposals, a new vision, but they're not radical in the sense that they are revolutionary. They're not revolutionary. They are radical in the original sense of the word. They go back to the roots of the 1949 Act. They go back to the aims of the Attlee government. They do represent fundamental and far-reaching change, a change of culture which is vital. But like the 1949 Act, the aim is to achieve justice for all. I'm proud to be at the launch of this publication. I'm proud to have played a small role in its production. Let's just hope it can be as influential as its predecessor 50 years ago.
The most important part, no pressure. So before we've heard arguments about the reasons, both moral and in public policy, of why we need a national legal service. But of course, a future Labour government, under our current policies and the current economic state we're in, must fund it. Now, I actually disagree with one thing that has been commented on, that we need to be creative on how to fund it. We don't. There have been policies which have already been introduced across the English-speaking world, whether that's the United States, Canada, or Australia. These policies, which have already been introduced, could generate up to £100 million worth of revenues, which would in itself create £250 million of government savings and over £650 million of economic benefits to the UK economy overall. As I've said, none of these are new. And in fact, 30 of these economic benefits, as you can see on page 28, have already been proven through studies. Now, these economic benefits cross 4 areas of focus for our suggestion for civil legal aid funding: immigration, family, housing, and employment. The benefits range from reducing court backlogs and the economic costs that those create, preventing domestic violence, helping partners gain restraining orders, helping to end homelessness and the cost that puts on council housing, and additionally getting people back into work and off benefits. Now, there have been 64 global studies on the impact of civil legal aid, which this chapter has analysed. And as I mentioned, some of these benefits in more detail really aren't minor. The cost of emergency housing, of an emergency shelter for a single household is over £10,000. The funding of civil legal aid system in New York, however, on household disputes resulted in a 25% reduction in the numbers who were forced into emergency housing. In the UK, those numbers could generate £200 million worth of savings. In terms of family law, we already know the horrific costs psychologically that domestic violence can cause. The UK government itself estimates that would reach up to £61 billion. In fact, 2.4 million individuals are suffering each year. And a single act of domestic violence has been found out to cost around £17,000 to the economy. Yet also, once again, we know that civil legal aid funding to stop domestic abusers can reduce domestic violence by up to 20%. Now, these figures are equally as significant for both employment and immigration law, but I won't go through these now. You can see them in the report. Overall, what 39 studies have shown is that for every pound that is put into civil legal aid, £6.62 is generated for the economy overall. These are not small figures. Now, the real question, of course, is how do we go about funding it in the first place, beyond the effective global economic benefits that can arise later? This chapter proposes three methods. The first is a 1% increase in the cost of court filings, which could itself generate around £20 million. The second is asking those who have benefited from civil legal aid to financially contribute back into it as well from anything in which they gain through successful cases. And the third is a method which provides the greatest deal of funding, but it also has been the most successfully implemented across the United States, Australia, and Canada. This is to collect pooled interest, money which would not normally create interest for clients held by solicitors, and rather than solicitors themselves holding it, giving that to charity to fund the civil legal aid system. That has been approved by the US Supreme Court and is effectively in place as the main source of funding for civil legal aid across all 50 states. Overall, these together could generate £98 million of civil legal aid funding, and when combined with the multiplier I mentioned earlier, could create £650 million into the economy and £250 million of government savings. Therefore, this is a policy which would perfectly fit into a future Labour government and the aspirations we hold, not just morally and politically, but also economically. Thank you.
I'm very conscious that we've got lots of people in the room who may have contributed to the pamphlet, or but certainly do have experience and expertise to be able to feed in. And while everyone absolutely should be encouraged to fill glasses and to indulge in the food, we thought we would try and start by getting the wider contributions from the room. And it may be slightly cheeky, but considering we do have some at the table who can not only speak when it comes to what Stephen had talked about from the perspective of MPs dealing with significant amounts of casework and acknowledging how many of their constituents can't access legal aid, but also with experience as Shadow Solicitor General, I wondered whether we could trouble Andy for his response to what he's heard this evening.
That's very kind of you, Andy. I'm Andy Thorpe, I'm the MP in Hammersmith, and I absolutely endorse what Stephen said. I think I was one of the people who took part in the evidence for that survey. And it's not just tragic, it's quite worrying that there are all these MPs out there giving legal advice with no basis whatsoever for doing so to their constituents in that way. And
you're one of the ones who are qualified to do so.
Yes, but not across the piece, as you're expected to do. So there we are. Well, it reminds me when I complained to my senior clerk that I was in 11 teams in Chambers. He said, "Yes, to be fair, so you're at the bottom of all of them." So I yeah, well, I'm not. So I'm not. I'm Chair Solicitor General. I know that because the Labour Party tweeted it this afternoon. And I thought, and I noticed all my colleagues were tweeted delighted to remain as, and I thought delighted not to be sacked. How pathetic! But then my researcher tweeted it anyway for me, and it was one of the most popular tweets I've done. And I thought, well, that's wonderful. And then I thought that's because nobody's known that I've actually had the job for the last 18 months in that way. But there it is. Shabana will be an excellent Shadow Justice Secretary. We normally have team meetings on Wednesday morning. We didn't have one this morning because it wasn't a team as such, but that is all being done. And I think that the reshuffle has been very good. And I think, and actually, year by year, Keir has reshuffled and strengthened the team on the basis of experience and identifying talent in that way. So I think it's very important that you engage with Shabana and her team as soon as possible, because I do think this is. You know, I did LASPO in committee for the LASPO bill for about a year, and I've still got the scars for that. And what we haven't been short of is advice. I mean, that's one of the good things about being in the justice team. You're never short of advice from the professional what you should be doing, and the number of reviews and reports that there have been over the time, Willie Barks and many others, have really built up to where we are now. And I think this is very much the right document at the right time, because it's something that is that's persuasive, well argued, well evidenced, and I think realistic, and is putting that forward at a time when, because the reality is this is the time the policy is going to be made over the next 6 months running up. Now, I can't say what's going to be in the manifesto or what's going to be accepted privately as the basis for policy. That's above my pay grade in any event. But I think this is exactly, I say, exactly the right thing to do at the right time, because it's, I say, it's realistic, but it addresses a real problem. I do think, and not across the piece, and I think that, again, I'm afraid that civil law is politically is the poor relation, because criminal gets, as we all know, 95% of the attention. But I think there is, if nothing else has broken through so far, the fact that we have a crisis in the courts, and not just the criminal courts, I think is on certainly politicians' radar and media and wider radar as well. And that's partly in the criminal context, you've got the overall crisis in the criminal justice system, but I think it's also to the family courts, the civil courts, and crisis that are occurring, as Nick was talking about, in terms of housing and things of that kind. And we are looking for a solution. And if you're presenting a solution that is feasible and workable, I think that's a brilliant start to where we are.
Thank you. Is there anyone else who would like to contribute? I think Nick, Roger, Nick has ably spoken to the chapter that you co-authored. But was there anything that you wanted to add before we?
Well, I think oddly enough, it's generally an incredibly depressing time. I've never known legal aid so bad, and access to justice so hammered. But actually, the extent of that evisceration of legal aid gives us an opportunity to look back at the model of legal aid and to think, do we need to change it? And I think, number one, we need to say in the modern sort of way, what's the purpose of this thing? It was originally phrased as being obvious as the benefit to pay practitioners to assist people. Go back to the objective and say it's about telling people what their legal position is, helping them through disputes in the most effective way. What follows from that? Number two, we combine the voluntary effort of the Citizens Advice Service and legal aid in one overall framework. I think that it dilutes the evident professional interest in legal aid. It combines us with an enormous sense of engagement of people, strengthens the case. Thirdly, it would allow us to put more attention to early intervention. At the moment, we fund at the end of the process, so we can fund it. If we have a strong strategic leadership, we should be able to better deploy innovation and technology. And I think this is the moment for when actually we could be quite radical. And as important in a way as the detail of the proposals is the chance here to set a structure, which in some ways takes on the community legal service that Labour left behind from the last administration and develops it further step forward.
Thank you. Is there anyone else that wants to speak, or is everyone quite keen to get to the drinks? Adrian.
Yes, I don't profess any particular expertise, but I just, no one's mentioned, I don't know what's discussing here, the Treasury in this. I mean, 100 million isn't going to be enough. It doesn't strike me as very likely that a new Labour Chancellor at the end of next year is going to be divvying out much money for this. Has there been any consideration of, for example, funding this through increasing court fees for large commercial cases?
Yes.
And then, Adrian, can you just introduce yourself before?
So I'm Adrian Williamson, Casey, Keating James, and I practice in construction. So, and when I started practicing in that field, we did do so. And obviously we don't now, because there isn't that much in that field or at all. So is that a possible source of funds? And the other thing is that civil legal aid, as it was conceived 30 years ago, was intended to be essentially self-financing, because mostly for claimants, if they won their cases, which they only pursued the case, the council said they had reasonable prospect of success, then the legal aid fund had first charge on the costs.
Can I answer that very quickly?
Yeah.
The answer is yes. It's dealt with in Roger and my paper, and it's dealt with in Joseph's paper in more detail. 2, recovery of costs is vital. Absolutely, totally agree, and it's in the paper as well.
Page 35.
But on the recovery of costs, one of the weaknesses in the old system was that usually to pursue a claim, council's advice, and I think council tended to be a bit flab. A lot of councils are a bit flabby in advice and not give the same trenchant advice one might give to a private commercial client, individual
Agreed.
commercial client. And if council really did give trenchant advice and meaning that only really pretty solid cases got through the net, that would make the self-financing system more attractive. And that seems to me, it would make the system more like self-finance, and that would make it more attractive to the Treasury. Because obviously anything with a sort of unlimited costing is not going to get through.
I'm going to hand over to Joseph,
Rachel's hands,
who literally wrote the chapter on it. So.
Hi. So I think one of the other ways in which funding coming for this is I did mention the £250 million of government savings, which is a realistic estimate based on statistics already out there. And what I would suggest is actually some of those savings could be put back into the system, so it almost becomes a spiraling effect. I'm not saying that's the answer, that's the full answer. And certainly we have suggested other methods as well, which have provided significant funding, including in the United States. But I think the point being that the 3 ones we have suggested are a good starting point to get the ball rolling for a system which we can envision going much greater in the future.
Could you just talk a bit more about the pooled interests?
Yes, of course, it's a bit of a technical point. I can provide as much detail as I can here, but I understand it is not the most interesting ones. So in the United States, what happens is, imagine you are a solicitor who's holding money for a very short term. Say you're buying a house, a client is buying a house. And so actually the interest that you could generate for a month or 2 holding that is minimal. The argument there is that actually the fees that could be generated by creating a separate account to hold that money is probably going to be smaller than the costs of creating that account in the first place. So actually there's no incentive for interest to be generated to create a separate account. So what instead currently happens is solicitors will put that money into a pooled account anyway, but they will keep the profits. If you go and type this in on any of the UK solicitors' websites, what they'll often say is, below a certain threshold, say £500, we will not give you any interest back on this. Or if we do, it's going to be given at 0.1%, compared to the rates we have seen, even this year, of 8 or 9% instead. So what the suggestion is in America is that all that money instead can be pooled together into a single account, which accumulatively can reach significant sums. And instead of that money going to solicitors, as it currently does, instead that money should be used to go to charity. Now, this is a controversial point. It has been so in the United States, but it's now one which is firmly embedded across the English-speaking world. And it's something which the US Supreme Court itself has given an endorsement to. In the United States, it generates around $200 million towards their civil legal aid system. And therefore, it's not something which isn't realistic. It can actually provide significant revenues towards a future system here as well.
I think you were first before we go to Dan.
I'm Carol Storer. I did do a paper, but I just wondered if I could take advantage of people being here to just do a bit of an update on something that is mentioned in a number of papers, which is the review of civil legal aid, fondly known as ROCLA, to separate it out from the criminal legal aid review, which became known as CLAR or CLARE. And it's referenced in some of the papers, and I've been to most of the stakeholder meetings, as have other rep body people here. But it's terribly worrying. You've got a major review of civil legal aid. There are 4 strands of work, and there is a lot that is unsatisfactory. And if you give me a glass of wine, I'll knock them all out for you. I mean, it's just, it's really hard to explain just how concerning that review is. I'm glad Richard from the Law Society and Swansea University is agreeing on it. So my question, and maybe a bit of a question for Andy as well as other people here, is so major review, lots of meetings. You would have thought an opportunity to really set out what should be done with civil legal aid, and yet you think, well, what's going to happen? Because there will be a new government, surely, fairly soon. The review will come out about the same time as hopefully a new government comes in. Is there any pointing in quitting? Will the Labour government look at something that essentially the civil servants have done at the end of this term of government? And it's a real issue because the level of dreadfulness of what is being looked at compared to the amount of time that it takes for us all to input, compared to, you know, are we going anywhere with it? So Andy, or anyone at this table, I don't want to derail, you know, this meeting, but it is something that has really, it has absorbed a lot of our time and energy in the last few months since we had the meeting. And it's driving a lot of us just absolutely to distraction, trying to work out how much energy to put into it. So the question is, what would the Labour government do with something like that? Is it worth our while putting energy in, or should we just go back to the discussions we're already having?
I'm going to hand over to Dan next, but the conversation here will be continuing when we move away from the table and closer to the drink. So we'll definitely get that glass of wine in use so that we can hear it all. But also, just so you know, that Carol's contribution is at page 8 of the pamphlet.
Catherine, can I just say, maybe I'm anticipating something Dan has said. My understanding is that it's been stated that the review won't actually publish its outcome until 2025, by which time, as a matter of law, we will have a new government, and presumably the extent, if at all, to which it's
yes, I mean, there will be interim reports, and but there is an absolute refusal to increase any fees in the way that the criminal review did actually increase fees. Yes.
It's a long grass exercise par excellence.
Yeah.
Thanks, Catherine. Dan Jones, member of the executive of SLL. I think it's a really excellent piece of work. I wanted to ask a question about how Labour's current policy, as set out, which Andy may have been involved in putting together when David Lammy was Shadow Justice Secretary, could be incorporated into this proposal. So some of you might remember that David Lammy's proposal was that firms like this one, or the one that I work for, commercial firms, would be expected to do a certain amount of mandated pro bono hours per fee earner to keep, for example, positions on government legal panels. I think at the time, it's fair to say it wasn't widely welcomed by the sector. Lots of people, I think, myself included, thought that it's not particularly viable or desirable to replace expert legal advice with those of us who have a core practice somewhere else doing it as a pro bono activity on the side of our practice. But there clearly is significant amounts of pro bono work that's being done by firms for whom lots of us work, and that isn't currently centrally coordinated at all. Each commercial firm picks the pro bono work that it does want to do and doesn't want to do. So I'd just be interested from the authors of the pamphlet on whether you think there's any scope that the National Legal Service could also be effectively used to coordinate the large amounts of pro bono work that's already done.
I mean, I'm not strictly speaking one of the authors, but I'll make these two comments. Firstly, I'm sure that a National Legal Service could give a lead on these things and could help to generate a culture within the legal community whereby solicitors and barristers would be willing to contribute. At the moment, there is no such culture because there's no real respect for any leadership that is given in the justice system. I would very much like to see this come about voluntarily rather than as something which is imposed. And that leads me on to a related point, which I feel very strongly about, which is that what we have to try to do, and I know that the leaders of our professions have always done this, and I did when I was chair of the bar in 2006, as no doubt is happening this year as well. But I think we have to try to develop the moral case for doing this. Ultimately, none of this is going to happen unless people feel strongly that it's the right thing. And one comparison, which I personally think is valid, is a comparison with the NHS. And one of the statistics which I always used 15 years ago, and I doubt whether things have changed, maybe they've got, as it were, worse from the point of view of the legal system, is that the NHS spends in a week that which is spent on the justice system in a year. Now, nobody's suggesting that that should be reversed. I mean, obviously, people's health is crucial, but I think we have to get across somehow in our society the importance of access to justice, especially, as I said earlier, for the people who need it most, who are the ones from whom LASPO took it away. That seems to me to be the moral imperative of the discussion.
I think that's actually a very nice point to bring this part of the evening to a close. But please do stay. I think there's lots more conversation to be had on this point. And please do eat and drink what has been provided. Thanks to Charlie Walker and Gibson Dunn. Have a good time.